This diagram maps the three distinct legal classifications of an adult relationship in England and Wales: valid, void, and non-marriage. Identifying this is the mandatory first step. Until this diagnosis is clear, a practitioner cannot accurately advise a client on their financial rights. Factors like mutual intent, the length of cohabitation, or emotional commitment have no impact on this legal status. Instead, validity relies entirely on strict adherence to two specific statutory frameworks: capacity and formality. We need to dissect the mechanics of how a relationship is formed and how its validity is proven under these rules. This also requires examining Section 9 of the Marriage Same-Sex Couples Act 2013, a unique mechanism that allows for the conversion of existing civil partnerships. An error at this stage can unravel a client's entire legal strategy. In Hamley law, the assessment of statutory compliance is the most critical baseline skill. This is the matrix of validity. We begin with column A, capacity. These are the absolute requirements that both parties must meet at the exact moment of the ceremony. These rules are primarily dictated by the Matrimonial Causes Act 1973. Under the Marriage and Civil Partnership Minimum Age Act 2022, both parties must be at least 18. The law no longer recognizes 16 or 17-year-olds as having the capacity to marry, even with parental consent. Next, the parties must not fall within the prohibited degrees of relationship. This includes consanguinity, or blood ties, and affinity, which covers relationships formed through marriage, such as step-parents and stepchildren. Finally, the law strictly prohibits bigamy. Neither party can be in a subsisting marriage or civil partnership at the time of the new formation. Capacity follows the individual. Under the dual domicile doctrine, anyone domiciled in England and Wales must satisfy these tests, even if the ceremony occurs abroad. Failing even one of these tests renders a union legally defective from its inception, regardless of the parties' intentions or the ceremony itself. If capacity is met, we move to column B, formality. These are the administrative and procedural rules found in the Marriage Acts 1949 through 2019. The process begins with a mandatory preliminary, giving a formal notice of marriage at a district registry office. Once notice is given, the law mandates a 28-day statutory waiting period before the ceremony can take place. The location is also regulated. Ceremonies must occur in approved premises or in permanently permitted outdoor venues. For a standard civil ceremony, the presence of a registrar and 2 witnesses is a strict statutory requirement. Specific religious exemptions do exist, such as the Church of England's publication of bans, but these utilize their own rigid frameworks that bypass standard civil notice. Valid formation requires both individual capacity and the state's administrative oversight through formality. English law recognizes nothing less than total compliance with both pillars. So, what happens when these formality rules are entirely ignored? We distinguish between a void marriage and a non-marriage. A void marriage is a flawed union with a clear intent to comply with the acts. Here, the parties can seek a decree of nullity. A non-marriage, or non-qualifying ceremony, is a union so detached from the statutory requirements that the state views it as legally meaningless. The consequences of this distinction were illustrated at the Royal Courts of Justice in the 2020 case of Akhtar versus Khan. The couple underwent an Islamic nikah, but failed to use a registrar, issue a notice, or secure a state certificate. Despite 18 years of cohabitation and 4 children, the court ruled the ceremony was so procedurally deficient it constituted a non-marriage, not a void one. Classified as a non-marriage, the applicant was denied a decree of nullity and barred from applying for financial remedies under the Matrimonial Causes Act 1973. A non-marriage leaves a party outside the protective framework of family law. This demonstrates that procedural formality is not a technicality, it is a prerequisite for financial protection. We must also consider how the law addresses historical restrictions on same-sex couples and their ability to form relationships. This timeline shows the decade-long gap between the introduction of civil partnerships in 2004 and the legalization of same-sex marriage in 2013. When marriage was open to same-sex couples, the state required a mechanism to upgrade the status of existing civil partners. Section 9 of the 2013 Act provides that statutory bridge. The procedure involves both parties signing a conversion into marriage declaration in person at a register office. The legal mechanic involves total retroactivity. As shown on the timeline, Section 9 does not start a new clock. Instead, the law treats the marriage as having existed since the date the original civil partnership was formed. This is a strictly one-way mechanism. Legally, a marriage cannot be converted down into a civil partnership. Section 9 functions as a retroactive correction of marriage validity, specifically enacted to resolve the legal consequences of previous statutory restrictions. Our completed matrix of validity unites the rigid baselines of capacity and formality with the Section 9 conversion protocol. The formation of an adult relationship in England and Wales remains an exact statutory exercise. A practitioner's assessment must rely on interpreting these statutes, unswayed by a client's length of cohabitation or their belief in the union. Failure to accurately determine if a relationship is valid, void, or a non-marriage will undermine any application for financial remedy. Mastering these requirements is the absolute prerequisite for effective and responsible practice in family law.